Hey all, Professor Tracy back with another negotiable instruments lecture. This one on negotiation, which has to do with the transfer of negotiable instruments. And in particular, a transfer of that instrument that makes the party who receives that instrument what's called a holder. So we'll talk more about that as we unpack things here in the lesson. We're first going to look at the three stages of life of a negotiable instrument. We'll see that the first stage is the issuance of the negotiable instrument, the second being the transfer after it's been issued, so the issuance being the initial creation of that negotiable instrument and the giving of it to someone for the purpose of giving them rights to it. And then the transfer here under number 2 is any sort of subsequent transfer by the person that received it at issuance, right? That it's transferred from them to somebody else. And then eventually a negotiable instrument is going to be presented to the person who is to pay it. And depending on whether it's a draft or a note, that person's going to be different, right? In the case of a note, it would be the maker of the note. In the case of a check, it would be the drawee bank that is the one being ordered to pay the payee. So we'll look at both of those situations, both with a check and with a note, and see how they work. So let's look in more detail. When we say issuance, what we mean under the code here, and this is a code-heavy subject, negotiable instruments. So under Article 3, Section 105, so 3.105 here, the issuance is the first delivery of an instrument by the maker, in the case of a note, or drawer, in the case of a check. And they're going to give it, whether to a holder or non-holder, for the purpose of giving that party rights on the instrument, right? Giving that person rights on that instrument. So it's that initial or first delivery. The transfer, and right now we're not going to look specifically at the code definition of this. We will unpack transfer a lot more further into the lesson. What we're meaning here right now is every legally significant movement of that instrument that occurs between the initial issuance of the instrument and its conclusion, right? Its presentment for payment at the end of its life. And so all of those steps in between, its movement in between, those would be falling under the category of transfers. And then presentment, as we said, is that demand for payment. It's the presentment, because remember, if we've got a note, that is the maker of the note is promising to pay a sum of money plus perhaps interest, that kind of thing. And so the presentment is going to be made to the maker of the note, right? The person that originated or made out the note to begin with. In the case of a check, it is the drawee bank that has been ordered to pay. So the drawer is the person who writes out the check and hands it over, right? Who does the initial issuance. But remember that a check is drawn typically off, or in the case of a check, always on a bank, right? And you're ordering the bank to make payment out of your account to the payee. So when the check is presented, it will be presented to the drawee bank, which is the bank that's being ordered to make the payment. So looking at some examples will help us understand exactly what each of these stages looks like. So let's look at the typical life of a check. When we talk about issuance, if we look at an example back from our first lesson where Bob is promising to pay Barb $10,000, she's promising to convey to him a Honda Fit. So we have this underlying contract. Now, if Bob then provides a check saying, I am going to make good on my promise to pay you the $10,000 by giving you a check, then he is the drawer of the check, right? That Barb is the payee, the person that is who is to be paid, And then remember that he's ordering his bank to pay Barb the $10,000, the bank being the party we call the drawee. So, and this, when we look at this initial giving of the check, right, it's Bob who created the check, wrote it out, signed it, and then delivered it to Barb. That initial creation and delivery of the instrument here, the check, by the drawer, right? Bob is the drawer here, that he's giving it to Barb. That initial transfer is called the issuance. So this is an issuance of the check to Barb, Then if Barb takes that check, right, we're now looking at transfer. So if Barb has the check in hand and she wants to deposit that check in her bank account, right? She's transferring the check to her bank, right? Giving it to her bank. That is called a transfer because it's already been issued, right? The check was issued by Bob when it was given to Barb initially. And this is not the check being presented, because it's not the check being presented to Bob's bank and saying, here, you're the drawee of this check, please make payment on it. Instead, this is a transfer from Barb to her bank in order to give them rights to the check, right? So they can demand payment from Bob's bank and then, and deposit money into Barb's account in this case, where she's trying to deposit the check. So this would be an example of a transfer. And we'll unpack more how this works, right? Exactly legally what's going on. But this is a transfer, right? It's a legally significant movement of the instrument, the check here, that is between the issuance and the presentment. So we had the issuance, now a transfer, and now we'll see presentment. So when Barb's bank, which has the check, then presents or demands payment from Bob's bank, right? Remember, Bob's bank is the drawee. They're the ones that were ordered to pay by Bob the drawer. He's saying, pay Barb, ordering them, pay Barb $10,000. So they are presenting this check to Bob's bank, Bob's bank being the drawee, and they're demanding payment. That demand for payment is what we said is presentment under 3501. And in the case, we said it's the drawee. So that's what's going on in this case. That's a presentment of the check. So those are all three stages of the life, in this case, of a typical check. It can be a lot more complicated than this is, but this is a typical journey for a check. What about a note as compared to a check? So with a note, the issuance, remember we have two parties with a note rather than three. We just have a maker of the note and a payee. So in this case, when Bob is borrowing money, let's say from his own bank, he's borrowing money, then he might, and in this case will, execute a note as part of that and give that note to the bank that as evidence of his promise to pay them whatever amount of money he's borrowed. Then that initial giving of the note to the bank is the issuance, right? It's the first delivery of the instrument by the maker, right? He's the maker of the note, and he's giving it to them from the purpose of giving them rights to that instrument, the right to demand payment from him, plus, in a lot of cases, the payment not only of the principal amount, but of any interest that may accrue. So that would be the issuance of that instrument, the note. So what about the second category here, transfer? Well, remember, he gave the note to his bank. And let's say, and this is common in the real world, that the bank has the note and decides that it wants to sell that note, that it would rather have money now than to wait for when that note comes due. And it would be priced, right? You would price that note according to the risks that Bob presents about how likely he is to pay or not pay or the full amount, etc. So, but if they want to sell this note, say to a giant financial institution, they want to sell this note. And so he is transferring it, moving that, or not he, the bank, his bank, which had his note, is transferring it by sale, right, to this financial institution. So this, again, it's not the issuance. The issuance occurred with the first delivery of the note from the maker, Bob, to his own bank as part of the loan transaction. And he did that to give them rights to demand payment from him. And now this isn't presentment, right? Presentment would be the note being brought before Bob and demanding that he pay on it because payment has come due. That's not what's occurred here, right? So this is a transfer. It's between the issuance and the presentment. So we said it's a legally significant movement, right? Because they're intending, again, to give some sort of right. So it's legally significant. They're intending to sell it, to give this financial institution rights, whatever rights they can be given with regard to this note. But it's not issuance and it's not presentment, so it's transfer. So with presentment then, this is when this financial institution, which now has the note and it comes due, it's time for them to pay, for Bob to pay, and it presents it to Bob and says, Bob, we're demanding that you now pay. That is, and he's the maker of the note. So this would be an example of presentment of that note, making the demand for payment, right? So that's all three stages of the life of a check and of a note. And what we'll see as we move forward in this subject of negotiable instruments is you can have a lot of transfers between the issuance and the presentment. But here I gave you pretty straightforward examples, but you can have multiple transfers. So let's look at that second category in some more detail, transfer and what we call a negotiation under this second category. And we already said, we've given this basic definition that a transfer is every legally significant movement of an instrument between its issuance and its presentment for payment. So, but the key thing to understand is not every transfer is a negotiation. Not every transfer is a negotiation. And before we delve into everything that means, let's take a quick detour to make sure we keep our terms straight. Negotiable is the term we focused on in the last lesson, our first lesson. Negotiable goes to the form of the instrument, of the note or the check. And we're asking, does it meet the requirements to fall under Article 3? Is it a negotiable instrument? Is it a negotiable? Section 3.104 lays out those requirements, and we walk through all 7 of those requirements, looking at things like, is it in writing? Is it signed? Is it payable to order to bearer? Is it a fixed amount of money? Is it a courier without luggage? And on, right? We said those 7 requirements. So when we ask if something is negotiable, that's what we're asking is, does it meet those criteria such that it's subject to Article 3 rather than just contract law? And then, but when we use the word negotiation here, what we don't mean by that is that you and I are just going back and forth and bargaining. What we mean in the context of Article 3, in the context of negotiable instruments, is the physical transfer of the instrument in a manner, right? The transfer from the transferor to the transferee that makes the transferee what we call a holder, which is a legal term, a term of art under Article 3. That it's a particular legal status. Are they a holder? Do they have the rights of a holder with regard to this negotiable instrument. And the key thing there we'll see in the next lesson is that not only is it important to know if they're a holder, but if they're a holder, they have the potential to be what's called a holder in due course, which is like a super status or super plaintiff, where they have priority and they have an interest and an ability to demand payment of that is free from a lot of claims and defenses. And we'll talk about that in the next lesson in more detail. But that's part of the reason it's key to know, is the person actually a holder? So again, negotiable, what we dealt with in the first lesson here regarding negotiable instruments. And this lesson is focused in on asking, is this transfer not just a transfer of the instrument, but a negotiation? Because it makes the transferee a holder. So when we go back then to looking at the material, and we go back to we looked at the typical life of a check. Let's focus on the transfer part, right? Remember that initially, it was issued by Bob to Barb in payment of the $10,000 for the Honda Fit. And then Barb takes the check and tries to deposit it at her bank. We said she's transferring it to her bank. And we have to ask, is that transfer a negotiation? Is it a negotiation? Because not every transfer is a negotiation. So if it is a negotiation, then the bank will be a holder, right? It will be a holder. And we'll talk about, well, how do we know? How do they know if they meet that, if they qualify as a holder? And if we look back at a typical note, when the note was made out, right? Initially, the issuance of the note was Bob, the maker of the note, issuing the note to the payee, his bank. Then the bank sold the note to the financial institution. We said that was a transfer. If this transfer is not just a transfer, but qualifies as a negotiation because it makes the financial institution a holder, then it's a negotiation, right? Then it's a negotiation. So if they're a holder, we have a negotiation. And vice versa, right? Those things are inverse of each other. So if a transfer is a negotiation, the transferee will be a holder, right? And vice versa, right? That if we've concluded, oh yes, they're a holder, well then that means there was a negotiation. It wasn't just a transfer of that instrument, it was a negotiation under Article 3. So what in the world is a holder? What do we mean by holder? There's two requirements to be a holder. And the person has to be in possession of the instrument. And when we say possession, remember that in the case of something like an electronic note or a check or an electronic instrument of some kind, that possession could occur through, for instance, what we talked about in Wells Fargo versus Good, where you have an official record, and the question is everything denoted in the official record the way it should be, and that you, the party, are in control of that record, such that you can be said to have possession of the instrument. And in Good versus Wells Fargo, the answer was they did not have control, right? They were not in possession of the instrument, and so could not be a holder. So you have to be in possession, and it has to be payable to that party, to that person. So the two requirements are, not only does the party have to have possession, but it then has to be payable to that person, meaning they could demand that it be paid to them. If it's a check, they can say the check you, Jolly Bank, should pay me. If it's a note, they can go to the maker and say, you, maker, must pay me. So if we look back at our typical check example, and we again remember that Bob's giving this check is in fulfillment of his promise to pay Barb $10,000, then initially we want to note here that even with the issuance, that Barb is a holder of that note, right? Wait, why? Because in this case, it's likely, well, one, we can say obviously she has physical possession of it, right? It's in Barb's possession. He gave her the check. But also, the normal way one writes out a check is it says payable to the order of the payee. In this case, Barb. He would write it out and says payable to the order of Barb. It would be payable to her. Payable to her. And so in that case, right, if it's payable to her, she, after this initial issuance of the check, would be a holder. Okay, and we're going to delve more into that second part, right? Because the payable part, right? Because going back here, if we look back, we can say, look, the possession part of this is fairly straightforward. I mean, I'm not saying it's always satisfied, particularly in the case of an electronic instrument. We saw that in the case, but that is normally, particularly in the case of a physical check or a physical note, something we can pretty easily decide. But the trickier element is the second one about how is it that it's payable to someone or not, right? And when we look at the check, right, this initial issuance, it's fairly straightforward because we can say, well, it's probably made out initially to Barb, so it's obviously payable. The check is payable to her. That's pretty straightforward. But we're going to look at that now in section 4 here in a little bit more detail. So when we think about is it payable, that second requirement to be a holder, we want to think of, there's 2 time periods. One is what we just looked at, which is who is it initially payable to? In the case of the check that Bob issued, we saw that it's likely it would be payable to Barb, at least initially. That's pretty straightforward. But it's that second part that comes trickier, which comes up in the case of transfer, right? The instrument has already been issued, whether it's the maker issuing that note or it's the drawer issuing that check. Then what happens after it's been issued and now it's being transferred? How is it that something made out to Barb can be made payable to somebody else, right? That's the question we're looking at. Or if it's payable to Bob's bank, how does it become payable to the big financial institution? How does that occur? And that's what 2 is about here. So let's look at the easy part first, which is to whom the instrument is initially payable. And when it's prepared, when it's issued, right, it's drafted up, it's written out, then it's typically either going to be payable to bearer, which means that it's payable to whoever possesses it, right? If it's written out, payable to bearer. And there are a lot of ways that occurs, but the most straightforward being it just says payable to bearer, but it could be payable to cash, something like that, that if that occurs, then it makes it a bearer instrument such that whoever possesses it, it is payable to them, right? It is payable to them. So it's payable to bearer. That's straightforward. But it could also then be payable to an identified person, which would probably be the case, for instance, with the check that Bob issued to Barb for paying the 10 grand for the Honda Fit. And one of the things we need to think about with this initial question of payability at who is it payable to at issuance is just, well, what if somebody makes a mistake, right? Like, what if they write out a check and they misspell the name, or they even write out the wrong name on it, or they write the name of an institution rather than the person's name. And what you want to know as you work through the material, the place to look for most of these questions about who is this payable to with this mistake or the way this is oddly done is to look at section 3.1.10. When you're asking about payable, particularly in this sort of initial phase, is 3.1.10. And the guiding principle you'll see in 3.1.10 is that it's the issuer's intent that controls. We're asking, who is it that they intended to make the instrument payable to? So if Bob, in writing out his check, misspells Barb's name, calls her Larb, or what if he totally calls her something else, right? Calls her Beth rather than Barb, or something like that. It's his intent that's going to control whether or not the maker of the note, the drawer of the check, got the name right. If they intended it to make that party payable, then that's who it will be payable to. So we do not, try to elevate form over substance here. It's whatever the intent was. The fact that a technicality, you got a misspelling or, wrote out the wrong name. If your intent was to make it payable to that person, 3110 says that's what controls. It is payable to that person because that's what you intended to do. Now, 3110 also deals with some miscellaneous issues. I just highlight two quick ones here. There are others that may come up as you're working through the material, but one of them is that 110 says, well, if it's made out to say three parties, like a check or a note, it says payable to Bob, Barb, and Herman, then it's payable to all of them, but collectively they must work together. They together demand payment. They together can make transfer. They have to act together because of the and, as opposed to if it's an or, then any one of them can demand payment, right? They're independent of one another, but it's payable to any of them, right? Any one of them independently. So it's the second category we want to zoom in on here now, which is, okay, we talked about, we've got an underlying contract with the purchase and sale of the Honda Fit. We've got Bob saying, I'm going to make good on my promise by giving you a check. So the drawer of the check, writes out a check ordering his bank, the drawee bank, to pay Barb the payee. They're the three parties of the check. And he gives the check, right? It's now been issued to Barb. Check. So we got the first stage of the life of a check. Then we said, what if Barb now wants to transfer that check to her bank? She wants to deposit it there. She wants to give them rights to this check, which let's assume that it's made out specifically to her, payable to an identified person when it was issued to her by name. And then she's giving it to them. The question we now have to ask, is that just a transfer? Or can this be a negotiation? Can her bank be a holder? They obviously now have possession of it, but how is it, or can it ever be made, something that's written out and made payable to Barb, be made payable to her bank, such that the bank is a holder? Right? How do they become a holder? We know they have possession, right? Now, one way to do that is, one possibility would be if we, instead of assuming it was made that Bob made out the check to her by name, that he made it out to bearer, right? Just to bearer. Well, that would mean whoever has the check can demand payment, right? It would be payable to whoever has it. And so whoever bears it, then that would, so simply giving the check, transferring the check to her bank would be not only giving them possession, but making it payable to them because it's a bearer instrument. The trickier question, though, is what if it identifies Barb by name, which is the much more likely thing when people write out checks, right? That they write it out to the party they intend to pay. So in this case, if that's what Bob did, how is it she can make that check payable to her bank? And it's through the use of what's called an endorsement. And it's spelled with an I, not with an E. If you look through the code, you will see that. Okay, so it's spelled with an I. It's an endorsement. And y'all do this whether you know it or not, y'all do it. Which is that we all sign the backs of checks, right? That's the most common kind of way. Endorsement comes up for a lot of us in that way. Whether we know that's called an endorsement or not, that's what we're doing. And there are two types of endorsements. One is what's called a blank endorsement, which frequently is what people do with checks, right? And we'll talk about what it is. And then the other is called a special endorsement. If we're looking at this situation, right, where Barb, let's say, again, in 2 here, let's assume that the check, when it was issued, it was made payable to Barb. It identifies her by name. Then she's trying to transfer the instrument, the check, to her bank, and we're asking, well, can that be a negotiation? Can the bank be made a holder? Obviously, they now have possession of it, but can it be made payable to them such that they're a holder? And the answer to that, we said is, well, it could by endorsement. Let's look. One possibility is Barb makes a blank endorsement on this check that's made out to her. And a blank endorsement is just signing your name. Just your name on the back here, Barb. That blank endorsement turns the check into what's called a bearer instrument. It's now considered payable to bearer because this is just her signature on the back. That she, the payee, has signed on the back. That makes this check, which was made to her, to an identified person, it turns it into a bearer instrument. It's now payable to bearer, and that's fine, right? That's fine as far as it goes because it turns it into a bearer instrument. Then by transferring it to the bank, giving it to them, they have it's payable to them, right? Because if something we said is payable to bearer, it's mere possession of it alone is enough to make it payable to you because whoever bears it, whoever possesses it, is the one it's payable to. So that would work to make it payable to the bank and make the bank here a holder, right? But the other possibility is a special endorsement. And you might say, why is this not good enough? Why is this not good enough? The dilemma with this, and there are many things that are potentially bad about this, but the problem with a bearer instrument, let's say you sign the check ahead of time, or Barb does, signs it, puts it on her desk, somebody takes it. Because it's now a bearer instrument that was signed by her, not a forged signature, it was actually signed by her ahead of time in anticipation that she was going to go deposit it at the bank. That in that situation, it's a bearer instrument. So whoever possesses it, it's payable to them. Because it's a bearer instrument. So it's not restricted, right? Which is why this second category of a special endorsement exists, which is you can put restrictions on it. So it's not a bearer instrument. So she could say, I'm endorsing this, but it's a special endorsement. She can say something like, pay bank, Barb. So in this case, and by pay bank here, I'm acting like the bank is just called bank, right? That this is their title. But, if they were Bank of America or whatever, pay Bank of America, Barb. Something like that, right? Pay Fifth Third Bank, Barb. Something like that. So that's called a special endorsement. It does not change it into a bearer instrument. It's payable to an identified party, right? It's payable to who? The bank. To Wells Fargo, to Bank of America, to Chase, to whoever it is, right? To that bank. That's restricting payment. So she's made it payable, right? It works just like the blank endorsement. It works to make the bank, the check payable to her bank, but it restricts it so that the risk, it doesn't turn it into a bearer instrument, right? It avoids all that risk because it's payable specifically to the bank. And so either of them is going to make, either the blank endorsement or the special endorsement are going to work to make the bank a holder, right? Because not only will they have possession, but it will be payable. It'll either be payable to the bank because the blank endorsement made it a bearer instrument and now they're bearing the check, or because she gave a special endorsement and made it specifically payable to the bank. So that would make them a holder. And it's important that they be a holder because they potentially are a holder in due course down the road. Next lesson. So one question we want to think about here though is, what if she messed up? What if Barb either forgot to endorse it when she transferred the check to the bank, or what if she somehow didn't do the endorsement correct and it's not specifically made payable to the bank, right? That the transfer occurs, that the bank has the possession, but it's not made payable. And this is key, and it's something we're going to revisit, but something to understand here from section 3203B is that if she is transferring that instrument, she's the transferor, right? And if her intent is to make the bank, to make them entitled to payment, right? To make the transferee bank entitled to payment, then even if they are not made a holder, and they would not be, right? If it's not made payable to them because she didn't endorse it either by blank endorsement or by special endorsement, then if she nonetheless transferred it with the intent to entitle the bank to payment from that check from Bob's bank, the drawee bank, then they still receive rights to payment, whatever right to payment they had, whatever rights Barb had, she is transferring to them. But they're not a holder, right? Because it's not payable to them. But they still have some rights. And if that doesn't make sense, you can just not sweat it too much yet. Keep it in mind, note it, and we're going to come back to it. But it's important to understand that it's not that the transfer, we would say it's not a negotiation because the bank's not a holder, but it's not that the bank has zero rights on that instrument. It's that whatever rights they have are the rights that Barb had, and they're not a holder and therefore could never qualify as a holder in due course. So we'll revisit this, but it's a key point to understand. Okay, so her purpose is transferring it to give them rights, and she messed up the endorsement or forgot to endorse it. So again, often people will talk about it this way, that in that case, under this code provision, 3203B, that we would say the bank basically has a lot of the rights of a holder, minus the ability to be a holder in due course. But they're not actually a holder, right? Because they would still have a right to demand payment. Whatever right Barb had to demand payment, they could still do. But there are other things, which we'll unpack moving forward, that distinguish these two paths, right? About, okay, I've transferred it, but I never made it specifically payable to the bank. So it wouldn't be the bank's not a holder. That transfer wasn't a negotiation, but there are still rights being transferred. So that's an important thing to note, put a pin in, and keep in the back of your mind. So when you make an endorsement, the code tells us there are 3 reasons that an endorsement is made. And you can even think of these as like 3 effects of an endorsement, right? That one is what we've just been looking at. It's to negotiate the instrument, meaning that I not only want to transfer and give you possession, but I want to make it payable to you. And that's what we saw Barb doing when she gave a blank endorsement or a special endorsement. The other is to restrict payment, particularly with something like a special endorsement, where you're saying I'm restricting it such that it's payable only to the bank, or you might say deposit only, or something along those lines. You're restricting it. The other thing to note as we're thinking about this sort of second line of inquiry here, or second reason here, is to say that not only could it restrict payment, but let's say that Barb gave a blank endorsement and deposited the check. The bank has the ability to itself go in and write a restriction on it, right? It could say for deposit only, for payment only to our bank, or pay to only us, right? To this bank. And that's not considered tampering or fraud or some sort of, misrepresentation or monkeying with the process. It's just understood that if I now have this instrument, I'm allowed to put restrictive language on it because it doesn't harm the transferor. Right? The person, Barb negotiated the check or transferred the check, which in this case was a negotiation. If in fact, not only she gave possession, but made it payable to them, they can put restrictive language on it to make it, quote, safe, right? It's no longer a bearer instrument. She gave a blank endorsement. They can restrict it. And that's fine. There's nothing that it's fine because it doesn't hurt the transfer. It doesn't diminish their rights or hurt them in any way. So the other thing is that when somebody endorses an instrument, that they incur endorser's liability. And you might say, well, is that really a reason? It is, and we'll talk about it more moving forward about what is the liability of someone who endorses an instrument. But you incur endorser's liability, that you are liable on that instrument. And so that's another thing that occurs. So in this case, with Barb, if she gives, in this case, let's say a special endorsement restricting payment to her bank when she's transferring the instrument, we'd say she gave the endorsement. Why? To negotiate the instrument, right? Making it payable to the bank. So she's going to transfer it and she's made it payable to them through the use of a special endorsement. And she's also, in this case, because it's a special endorsement, she's restricted payment to the bank only. So that's another reason for doing it. And because she endorsed it, she incurred endorser's liability, which again we'll unpack later. So what about this? This is something to again note, and it's vital to understand, and something that will come up again as we move forward, which is when we think about the payee, right? The payee in the case of the check would be the person to whom the check was made out, right? When Barb would have been the payee of Bob's check. In the case of the note that Bob made to get a loan from his bank would be his bank, right? He's promising payment to them. And one of the things that comes up is, what if when it's being transferred, that instead of Barb signing it as the payee, that there's a forgery, that somebody comes in and forges her name in order to say maybe transfer to their own bank, right? So let's say they forge their own name. So let's look at an example. So again, we stick with this. Keep in mind, we have this underlying agreement where he's promised to pay $10,000 to Barb, and then Barb is promising to provide a Honda Fit to Bob. And in performance of that promise, Bob has given Barb a check. In performance of his promise to pay the $10,000, he's given the check. And again, another thing we'll talk about is, what's the effect of giving a check to somebody? What effect does that have on the underlying agreement? Right? Because it's like, well, what if we all know that checks bounce, or maybe, someone puts a stop order saying, don't pay on this check number, blah, blah, blah. Well, okay, what does that uncertainty do to the underlying agreement here? And we'll talk about it. Let's assume, though, in this situation that Barb had the check stolen by Evil Bo, right? Evil Bo comes in and he says, I want the check here, Barb. I'm taking the check. So he takes the check from Barb, and now he endorses it, right? So remember, the check was made out to Barb. Barb is the payee of the check. Then Bob forges Barb's signature, doing a really bad job, right? Compared to what her signature looked like. So, and here it's made payable he's forging the payee signature. And remember, it's a blank endorsement. And so it's now a bearer instrument, hypothetically, which you could say, well, doesn't that mean now that Bo has possession of the instrument and it's payable to him because it's a bearer instrument? He's bearing the instrument. And so what we're going to ask is, well, what happens because it's a forgery? The payee's name, Barb didn't write that name, right? This isn't a case of she wrote her name on there and then the check was taken off her desk. This is, the check was there, and she either lost, or it was stolen or misplaced or whatever, and Bo took it and forged her name. And so Barb never intended to endorse it at all. She didn't endorse it with the intent to make it payable to anybody, right? So Bo's doing it in this case with a forged signature. And our question we're asking is, well, what happens when you have that forged signature? And let's say he decides to take this check he took from Barb and forge the name on, and he gives possession to his bank. He says, here's the check. You now possess it. It has a blank endorsement. Yes, it was forged, but you're unaware of that bank. You took in good faith. You have no notice of any forgery or problem, assuming nothing's obvious from the face of it. Then in that case, it's like, well, is the bank a holder? Can the bank demand payment from Bob's bank, Bob Drawey Bank? Is that what's occurring? Or can the bank qualify as a holder here? And that's the question we have to address, is what's the effect of the forgery? And this is key, because the answer is no. In this case, the unauthorized signature, right? This signature, Bo's forgery of Barb's signature, Barb the payee, her signature was forged. That is not effective to negotiate the instrument. He cannot turn it into a bearer instrument by forging her name. She never signed it. She never had the intent to make it payable to his bank. That forgery means that not only is his bank not a holder, nobody subsequent in the chain here can be a holder because of the forgery. And it doesn't matter how innocent they are. because the payee's initial endorsement was a forgery. And that's really important to understand. We will revisit that, but keep that in mind. So those are the basics of negotiation and transfer, the life of an instrument. We're going to look in a lot more detail in why is it that we care about somebody being a holder and potentially a holder in due course. We'll look at that in the next lesson. Until then, I wish you the best of luck. I hope that your studying is going well and that you're enjoying your winter break. So if you found it helpful, please do like and subscribe. There are more on the way. Thanks as always for your support, and I will talk to you again soon. Bye.